G'day, how are you?
Good, thanks, Andrew. How are you?
We've got a different setting today because when you have a bald head, it shines in light. So you can't actually see it. It looks like a Dan Aykroyd cone head with a light on it. So we've changed around so I don't have a cone head. I might have, I don't know.
Make that a hashtag. Hashtag FWB Conehead.
Don't do that. Nobody be laughing at that. We're going to talk about principal contractors, occupiers, independent contractors, and the whole shebang a bit later. Partly because, although the law is not controversial,
it shouldn't be controversial.
It shouldn't be controversial. In fact, there's been settled law now for around about 50 years or longer. We continue to have some hyperbolic extremes of polarized conversations which said if you use an independent contractor, the occupier can never be liable, or the principal contractor can never be liable. Not true. And others saying, oh, they're completely liable. Everyone's liable. And we just want to talk about the common law, and I'll talk briefly about safety law because safety law is quite different. And again, it is in an arguable position. But it's really to douse the noise, and so people who are out there can go, okay, I totally get that. And I'm not going to be confused by it again. So if we take it back to first principles a bit and you think we're telling you how to suck eggs, I'm sorry, but I just want to be really clear what the law is when we talk about it. But why don't we go and talk? We could have had a week about the CFMEU, couldn't we, this week, with the appointment of an administrator and all the other issues. But let's get a bit of a wrap up on that next week when everything's more settled, and just move on to sort of some legislative change and award changes that are happening.
Yeah, there's been a lot, actually.
There's been a lot, I think there has. So let's jump to our next slide, which is the notification of injury stuff for Safe Work Australia.
Yeah, so it's not in effect yet. Safe Work has kind of come out and said these are the changes we're looking at as to what will be notifiable injury, and it will come into effect in 2025.
Has to be adopted in each jurisdiction.
Yeah, that's right. So it'll come into effect, but each harmonised jurisdiction still has to adopt it. But all the WHS ministers have shown their support for it, but it's quite broad in terms of what it's going to extend it to. So
some of them are quite startling, aren't they? So any death that could be related to work, whether it's suicide or would be a notifiable incident. I think it's lovely when people have ideas like this, but do they understand the level of complexity that could sit around such an issue and the nature of the inquiry that could be made, which could be so hurtful and damaging? Sometimes in trying to be good, we're not so good.
Well, I think they have said regarding the suicides and attempted suicides, there has to be a causal connection and plausible link to work in order for it to be notifiable. And I guess because the employer is the one notifying, they would have to be aware of that connection.
I know, but the difficulty is they can be prosecuted for failing. And that's the part that I'm talking about, because what it does is it puts an obligation, almost a loco parentis obligation, on an employer to actually inquire into circumstance to see if there is a... Anyway, I just raise it because I'm really bothered by it.
I feel like, though, I get where they're coming from. Like, a lot of the new changes are around capturing psychological risk, because the current notification is really narrow. So, for example, it's going to include any violent incidents that don't actually result in physical injury but has a psychological risk, which wouldn't be captured under the current things. No. And they really should be.
No, they should be. Like, by the way, I just raised the one issue, because the rest of around head injuries, serious crush injuries, all those type of things, I think are just terrific. And because...
And injuries where people will be off for more than 15 days. Like, it's crazy you only have to notify if someone needs immediate attention. There is so much more that could happen in a workplace.
So I think probably go through them quickly anyway, because I've managed to steal 3 of them and talk about it.
So non-injury causing acts of violence, dangerous incidents involving falls, electrical hazards and mobile plant. We already talked about the suicide, serious head injuries, crush injuries, bone fractures, and serious work-related injuries and illnesses that are not immediately notifiable but result in a worker being absent for 15 or more days.
So look, we're going to, unfortunately, Victoria haven't shown their hand because they don't turn up to the meeting, so it's not helpful. But I would imagine there's some parts of this already would be reflected in the psych regs if they come through. It's going to capture the psychological parts, but it's not going to capture the physical parts. What I'd love to see happen is genuine harmonisation, at least around things like notifiable incidents, because it is very hard to train different jurisdictions to behave differently. And these are good. These are sensible things. As I said, the issue around psychological hazards and suicide, I struggle with, and I struggle because we are putting a higher obligation on employers to inquire in circumstances where they could easily cause more harm. But that's an issue which we can discuss at another time.
I think we've got to see what they put out and like the guidelines and framework around it.
Yeah. All right. Well, let's jump on to the next thing and see what's happening in Queensland, which you just told me is sort of replicating what would be in the psych regs in Victoria, but only in relation to sexual harassment.
Yeah, so they've made changes in regards to sexual harassment, made it very clear that it is a positive duty, which it is everywhere in Australia. But in terms of specifics, now I think this year, from September this year, businesses will have to have tailored approaches to protecting people, individuals and groups from sexual harassment. But from next year, early next year, under the new regs, they will have to do a written prevention plan, which I think is going to mirror the prevention plans that Victoria have brought in through their regulations that are still not into effect.
But those plans arise after an incident. So once again, we're going to end up with different states doing different things. And I know we can complain about that a lot, and I really do want to complain about it a lot. The Queensland provisions around their psych hazards is cumbersome, bureaucratic, and foolish. It just makes life hard to live up there, and there is no good reason for it. Psychological hazards are not like normal hazards. Normal hazards, you don't necessarily get hurt. Psychological hazards, they hurt every single time. Psychological hazards come in clumps, not in individuals. You can't see them, they happen. So applying the cosmetic lens of physical hazards and the documentation of physical hazards psych is a complete bloody nonsense. But Queensland are doing this, and they're building this edifice of paperwork which is going to live up there, which is not going to make anyone any safer at all. But it will keep somebody sitting behind a desk busy just writing stuff. And this plan around sexual harassment, look good on them. You know, if we can stop sexual harassment, it just has to stop. But writing a plan, I suspect, will do not much. Anyway.
Yeah, I think it'd be more effective if, say, you did a safety plan, which you should be doing, and considering the risk of sexual harassment. I guess the point is to make people pay attention and think about.
Oh, look, it is. But what we've got is a sort of paper mache of different obligations that sit there, none of which line up properly. But look, Queensland's a funny place in safety. What can I say? Okay, let's move on. All right. I reckon this is an interesting case, actually. So this is a case of a regulator who entered into the property under mining safety law. There
was an incident where someone had died.
Yeah, an incident where someone had died. Their actual right of enter existed without having to produce a particular warrant to actually enter. The warrant was wrong. And the company said, under that basis, you shouldn't be able to collect any of the documentation, which were 14,000 emails.
Which they had collected.
Which they already had collected. Yeah, and I think Twain sort of having a quiet chuckle and just saying, but the legislation says you didn't need to do what you did. There was a right of entry anyway, and a right of collection. Don't get it. It's probably one of the more interesting parts of the case. But what I want you to understand is when a regulator attends, whether it's under mining safety or whether it's under any other safety law, they're allowed to come on site. There's a tip. They are allowed to inquire. They're allowed to take photographs. They're allowed to require the provision of documentation.
And to copy and inspect it of the day.
Yeah. So don't be, again, I know I use this phrase too much, don't try and be too smart by half. They are a regulator. They're a policeman at one level. Actually telling them to piss off and go away and I'm not going to give you things is sort of nonsense and silly stuff and the type of thing which makes you a target.
Yeah.
Only a dumb person would do it. Don't do it. I mean, just don't do it. They're going to serve you with a notice as to what documents they require. Get advice. You don't have to hand over everything. Not all of them are relevant to the issue of inquiry that is being raised. But do not frustrate a regulator or they will come down on you. And you will lose because they have incredible power. So get some advice, but don't pick fights. That's sort of my view.
Yeah. And also, had they just done stuff under legal professional privilege, it wouldn't have been accessible anyway, even under the request. So I think that would have been
Yeah.
a way to prevent
there's a lack
14,000 documents being taken.
Yeah, anyway, there you go. All right. Well, where are we up to now? I think we are on to
Casual conversion.
casual conversion. Talk us through this, because I don't think it's any different than just change the legislation, is it?
No, it's really not. So obviously with the closing the loop, they've just made it easier to change to be casual. So now there will be a new process where it's compulsory arbitration under the Fair Work Commission if you have a dispute. And obviously we all know about employees being able to request in writing for an offer if they've met the 6-month period or 12 months if it's small business. So all that's happening is really they're updating the modern award clauses to reflect what's in the Fair Work Act.
Yeah, what's in the Fair Work Act. And I think it's worth remembering that under the changes in closing the loop, there is now a number of acquired jurisdictions for the Fair Work Commission. And one of them is this, whereas if you can't resolve this at a conciliation process, then the matter proceeds to arbitration, just like an unfair dismissal case does. So when you're looking at casual conversion, when you're looking at making casuals, can you please start by building the business case that they are a casual?
Yeah.
And be thoughtful about that process, because otherwise, you've employed 20 people. Suddenly you're faced with 20 potential part-time or full-time employees. It's something you should have thought about at the very beginning. So build your business cases to why they're casuals at the beginning. Make sure that you're able to evidence the reasons that sit behind that and stay with it. Okay, main topic. So the main topics comes out of a Court of Appeal case in New South Wales called Val Value case, and it is a case of an occupier, and the occupier had a pit, effectively, or a hole in the floor that should have been covered by a metal grate.
Storm drain.
Yeah, storm drain. And the builder who'd come in, or the independent contractor who'd come in, had actually covered that storm drain with some black plastic. And
but removed the grate.
But removed the grate. Maybe not removed the grate. The grate wasn't there. Nobody really knows.
It was just somewhere else. Yeah.
What was very clear is that the occupier knew that was there. Probably knew, or ought to have known, the grate had been removed before the plastic was put down, and a worker, quite unrelated, was just walking across and fell down that hole. Now, this is a case which is caught up in the pleading, or how you craft the claim. So there's a lot of issues that don't relate. But the New South Wales Court of Appeal is a very powerful and good Court of Appeal, and so they spent some time going through what the law is. So I'm going to tell you what the law is, and then we're going to break it up a little bit. The law is that an occupier, so a commercial occupier. Now, an occupier can be somebody who has complete management control, can be an occupier, or it could be the person who actually owns the premises, has a common law duty to exercise reasonable care to prevent foreseeable harm. Now, did you hear that? That's what they have. They don't have no duty. Now, when they appoint an independent contractor to work, a contractor to work for them to undertake specified work, it is not assumed at common law that the occupier will have a liability to manage the safe system that the contractor uses. It is assumed that the contractor has that responsibility. And this is where the confusion starts, because a group of people say, well, that's why you use contractors, because contractors take away, they absolve all the duties of the principal, or the occupier in this case. But that's not what the law says. The law says, actually, to the extent that the occupier does create a risk, it can't be fixed by an expectation that the independent contractor will fix that because of its skill.
Yeah.
There's dual liability.
Yes, and it can't be split. That's such an annoying misconception.
Now, that gets a little bit more complex, where you know that the occupier appointed somebody, that they had reasonable concerns about their competence in carrying out their specified trade, or that the occupier had a shared knowledge of risk in respect of the trade that was being carried out, and therefore was able to observe obvious risks that were being carried out. So you see, the law is not dumb. At common law, it's really clear that courts over a long period of time have said there are specified duties, like employer to employee, which is a non-delegable duty. You can't palm it off, okay? But there is underlying duties that everyone has based on the circumstance of a case. So an occupier, someone who has exclusive management or control, or say a principal contractor who comes on site to undertake work, has a residual duty to exercise reasonable care to prevent foreseeable damage. That never goes. Now, it's not a high duty like somebody who's doing a specific task has to do that specific task. But if we use the classic circumstance of a builder who has been appointed to undertake work, they have the general duty described, then they have specific knowledge duties that arise because of their skills as builders, which they can't get rid of. Just because they have an independent contractor to go and do demolition works, they see someone doing demolition works 3 meters above the ground. They're a builder. They know about working from heights.
Everyone knows.
They see that danger in a premises that they're managing. They're on liability. Okay. So you can see this isn't hard, is it?
No.
But it's not one thing or the other. It is not, okay, I'm going to appoint a contractor. And let's just say I'm a manufacturer. I bring a contractor to come in and work on a machine. Do I have any liability in respect of that contractor working on a machine for that contractor's employees? The answer is yes. Okay.
But that contractor also has obligations.
Oh, they do too.
It's not one or the other.
Yeah. So let's say the contractor comes in to work on a machine and they're an electrician. Okay. When the person goes to work on the machine, the manufacturer knows that there are problems with the electrics which create immediate risk to someone, and that's why they've brought in the electrician. So they're on knowledge of that risk. They can't see an electrician go in without depowering the unit and think it's okay and it's safe. It's not. If they look at the swings that has been provided and they see there's no depowering of the site before someone goes, they know that's wrong. They're liable. So is the electrician if they're still alive. But I want you to be clear that it is a state of knowledge of risk that creates liability that you can't absolve yourself and wash away by the appointment of a contractor. That's the nonsense that we hear. On the other side, we hear people saying, oh, well, the builder's liable for everything, the principal contractor or the occupier, they're liable for it. That's not true either. They're liable for known risks, okay? They are not liable for people exercising their expertise in doing work for risk which is not within the skill set. But if they observe something which is within their skill set, which is a risk, they cannot turn a blind eye. So that's the law, okay? Now, I hope I haven't made that too. Did I make that confusing?
No, I actually think you simplified something for
Okay.
us.
And look, when we come to safety law and you look at the definition of what a worker is, just say in Victoria, Section 5 makes it absolutely clear that it is a contractor's employee as well as worker. And there are other provisions in each state which recognise that for the purpose of safety law, there is this continuing liability that exists for a person who is an occupier or management control person or a principal contractor over subcontractor's employee. It is understood as a matter of law that there is a liability. So what it comes down to in safety law is the factual analysis of hazard and risk and the controls that should have been in place and who, so it's a principal contractor, are they satisfied that the contractor coming in is doing everything that is reasonably practicable? And once they are satisfied, and that is a continuing obligation on the principal contractor, then they are absolved from liability in relation to a subcontractor's employee, and the subcontractor will sit alone. But remember, it's not a zero-sum game. They are each independently fully exposed to liability, each person who participates in it. That's not only the organisation, it's the officers of each BCBU or employer, and it is the supervisors, managers, and employees all have an individual silo of liability which is independent from the others. Okay, so I hope that makes sense. The common law was codified in 1970 in the very first safety legislation. Okay, it's changed dramatically through interventions and statutory interventions throughout Australia, which make it very different to what the 1970 common law was like. So the common law now has evolved in one stream, legislative law has evolved in another. They are very different. Okay. There you go. I feel like taking a breath after all of that.
Now that's good.
Okay, good. Why don't we give it a bit of a test and run it through a bit of a complex problem I've got where the answers aren't completely clear on that ad. It's just really to test where we're up to. So let's go to our case study. I think it's a bit shorter this week too.
Baz Build BB was the principal contractor renovating the site for King Kong Experiences, KKE, an adventure park operator for children. The renovation was of a large warehouse in Collingwood to create various game and adventure experiences for children. The warehouse had a refrigerated area beside which was a hole at the entrance of a pit, leading down to an old refrigeration unit and gas tank, which had several protruding iron bars preventing access to the tank. Across the top of the pit was a metal plate that was ill-fitting and moved sideways easily if stepped on. The risk associated with the plate and the pit was not known by BB at the time of taking control of the site. BB took exclusive possession of the warehouse site on 2nd of February 2023. BB engaged several contractors to undertake specialised work. The demolition business Smash Trash, ST, was engaged to demolish the refrigerated area and make the area safe for the installation of trampolines. ST used Ready Hire RH for labour. On the 6th of May 2023, Pete Tampras, a labour hire employee of RH, was directed to remove wiring 2.6 metres above the ground from the refrigerated panelling. He had undertaken an induction before starting work run by ST. It dealt with many generic issues, including working with heights. He had signed the SWIMs dealing with the demolition of the refrigerated area, but there was no description of the job he was directed to undertake. Pete noticed a large 4 metre length skip bin near the wall where he had to remove the wiring. He asked the forklift driver Dan to move it next to the wall, and Dan moved the skip as asked. The height of the skip was 1.8 metres. Pete used the ladder to climb up on the skip, and then he moved to the wall side of the skip and reached up to start removing the wiring with a claw hammer. The movement of the skip bin and subsequent actions was observed by Mick Clutch, the managing director of BB, Danny Kong, the owner of KKE, and Jen Dang, site boss for ST. They watched, bemused by Pete and his antics. Danny turned to Mick and Jen as Pete climbed up on the skip bin and said, "Novel way to do this." They all laughed. Unfortunately for Pete, the wiring gave way easily as he pulled. As a result, he fell backwards onto the edge of the skip, bouncing off, hitting the metal plate, which gave way, and he fell into the pit and was fatally impaled on one of the protruding iron bars. Gosh.
What a terrible story. All right. So could King Kong Enterprise, who is the
So many people.
Yeah, so many people. Could King Kong Enterprise be liable in safety law, and why? Well, this is exactly what the value case was about. There was something that was known, they knew about it, and they weren't in a position to know that it was safely being managed. And that's the test.
Yes, they hadn't verified that there was sufficient control.
So they're definitely liable. Now, BB is the builder, okay?
So like the principal contractor?
The principal contractor, okay? So could they be liable in safety law? Absolutely, because
same
their obligation was to identify hazards in a workplace. Remember reasonable practicability, identify hazard, determine its risk, and institute a control. They simply hadn't done that, okay? So they
In fact, they all sat and watched him do the unsafe thing.
They did. Now,
so they're all liable under reckless endangerment.
Well, yeah. Look, let's break it down. There's certainly, let's get to RH and then go backwards, if that makes sense. Because I think so. ST, which is the demolition business.
Yeah.
Yeah, they're absolutely liable. They've got a guy there. They had to make sure the area was safe. Forget about the fact that they saw him doing something unsafe. We'll come to that.
Like they've done a proper risk assessment.
None at all. Yeah. Okay, so they're gone. And RH, because they are the employer, are most definitely liable. Yeah. And this is one of the things for labour hire providers who think they get away with site inductions. They don't. So they're all primary duty breaches without difficulty. The next thing is...
And the host employer has to treat the labour hire as their own employees now under safety law.
That's right. Yeah. So both of them...
ST and RH.
Yeah, both liable there. So the next question is reckless endangerment. Was there a risk of serious injury? Yeah,
yes,
there was. Were they indifferent to it? In other words, had they addressed it? Well, they actually hadn't addressed it at all. So the short answer is they are all potentially liable for reckless endangerment. BB is in deep trouble, and so is ST for reckless endangerment.
But even more so the individuals who watched, right?
Yeah, definitely individual. Well, once the individuals watch, that's attributed straight to because safety law is a law of attribution. So if one person watches, who is a director or officer, then the business is deemed to have that knowledge. So I think the difficulty here is that as far as BB goes, and probably KKE and ST goes, you've got industrial manslaughter.
Yeah.
It's just running at you because there's obvious breaches that exist there, and they're breaches that are contemplated under the legislation.
Yeah.
They are of an unspeakably high level. You've got something which is a deep hole with sharp objects pointing upwards.
Yeah.
You couldn't have something more dangerous.
And there was no controls at all.
And there was no controls at all. So if we come then to Mick, Danny and Jen. Now, let's just say Jen as the occupier.
No, Jenny is from ST.
Jen is from ST?
Yeah. And Danny is KKE and Mick is BB.
Okay, I wrote this too. Anyway, I think the occupier in this case has really significant liability. So I think Mick has very significant liability because Mick has or ought to have the knowledge, and that's certainly what the case law says. So the primary duty breach, but I think that's much more than that. I think that these people forget about the whole. They saw someone doing something. They knew it was inherently dangerous.
The wheelie bin case where that 72-year-old went to jail for it.
Yeah, Jackson.
Yes.
Yeah.
Maria Jackson, I think.
Yeah. So this is a case where all of these people are looking at definitely reckless endangerment and probably industrial manslaughter. So
they all need to grab a toothbrush.
They do need to take their toothbrush in their top pocket. The reason I show this case is there are some real arguments in between about whether liability would attach based on the contractor law, but that's in common law. Okay, I'm talking about safety law.
Yeah, and everyone's liable.
And everyone's liable here. There is no escape for them. The issue for KKE is whether the liability attaches to both the whole and the working at heights incident or just the whole. So there's an argument to say it's not their place as the occupier to be involved in the elevator.
The working with heights,
But the working at heights next to the whole connects them evidentially.
But also working from heights is an obvious known risk. Although it's specialised work, I think it's arguable that they witnessed it and should have stopped it as well.
Look, I think as a true occupier as KKE, they may not be liable for the working at heights, okay, even in safety law. But the working at heights next to a hole, unquestionably. Okay, so the hole's the issue for KKE. For the rest of them, it's everything.
Yeah.
So look, there you go. We took it for a walk, didn't we? We said common law, and then we gave you a safety law problem, and you kept thinking about the common law. And I did that for a reason, because I want you to understand the common law has nothing to do with safety law. Safety law is legislative. And when we talk to you about what the safety law is, you're probably all going, The only question was the level of knowledge or state of knowledge of risk that attaches to KKE over the working at heights. And I don't think they'd be punished for that, except as it pertains to the fact there was someone working above a hole that is significant, which made the hole so much more dangerous. There you go.
Thanks for joining us.
Yeah, let's talk about the CFMEU next week and see exactly what is going to happen with them. Yeah, thumbs up. Cheers, guys.
Bye.